Good afternoon, welcome on in to another episode of From Day One. Today we start with a court case with a guy doing self-representation, where the situation just gets worse and worse, and before it gets better, it gets worse. Along with us is Law Talk with Mike, and we may be splitting this over both episodes today, so let's get started.
Alright. Mr. Ireton, if you could come forward and have a seat right here, please. Alright, good afternoon. We haven't met yet. I'm Judge Lacoste. People of the State of Michigan versus Jeffrey William Ireton, 237405FY. Mr. Ireton appears here in court this afternoon. He is not represented by counsel. I think we are set for a continued probable cause conference. Mr. Ireton, I've been gone for a judicial conference. Today is my first day back in the office. I understand you've met with the magistrate prior to today, and she set the matter over to today's date. Is that correct, Ms. Cass?
It is, Your Honor. I believe Mr. Ireton wants to represent himself, and there was a question of standby counsel that the magistrate wanted to meet for the court.
All right. So, all right, Mr. Ireton, let me look in the file here. Did you go over an advice of rights form initially? Yes, when you had CAPA counsel that day. Did CAPA counsel ever meet with them?
Yes, Mr. Seibel did attempt to meet them.
Attempt. Do we have a signed advice of rights form? Did you go over the advice of rights form, Mr. Ireton?
I believe we did, Your Honor. I was not inclined to accept him as counsel.
Can you put me on a register of action? Alright, so in regard to this matter, then, the record should reflect Mr. Ireton is here today. He is not...
You might be holding out for M&M.
...represented by counsel.
No, Mike.
Sir, what is your full legal name, please?
Jeffrey William Ireton.
Alright, Mr. Ireton, I'm going to read for you the advice of rights form. First, I'll see if it's in here, if anybody went over that with you. And if you don't want to sign it, that's fine. I'm just going to make sure that the record covers that I've read it to you, okay?
Very well, Your Honor.
That's right. Thank you, Natalie.
I don't see that it's there. I'll make sure that I read it just to be cautious.
It's a slow descent.
In the chaos and anarchy?
Alright, here we go. Alright. Mr. Ireton, you're here today because felony charges against you were filed with this court by the prosecuting attorney's office. Normally, this is read at your first appearance. That's called an arraignment or an initial appearance. You're beyond that now. So you are at a probable cause conference, continued probable cause conference. You will not be asked to plead guilty or not guilty at this hearing. This hearing is only for the purpose of advising you of the charges against you and the rights you have before being asked to defend against the charge or charges. You have the right to demand a preliminary examination, at which time the prosecuting attorney must establish that the crime you are charged with was committed, and there is probable cause to believe you committed that crime. You have the right to waive or give up the right to a preliminary examination and voluntarily go to the circuit court to enter your plea of not guilty or guilty. You have the right to be represented by an attorney of your choosing if you hire your own attorney. If you cannot afford an attorney and the Michigan Indigent Defense Commission determines you are indigent or without funds after a review of your financial assets, they will appoint an attorney to represent you at public expense. If you want an attorney, the hearing today will be continued to allow you time to consult with your attorney. You have the right to talk to any law enforcement officers. However, anything you say probably will be used against you. You have the right to talk to the law enforcement officers by voluntarily giving up your right to remain silent. You have the right to be released on a reasonable bond pending further proceedings. You understand all of those rights then, Mr. Ireton?
Yes, Your Honor.
All right, thank you. respect to the matter, then, it's my understanding from what I've been informed of from the magistrate is that you want to represent yourself in these proceedings. Is that right?
I don't know if I'm being too technical. It's not that I want to represent myself, Your Honor. I would much prefer to have just any counsel at all. I think is a good thing. I have respect for counsel, but particularly someone who understands the format and nature of these proceedings, given that I'm not familiar with them myself. But having seen what I've seen and experienced what I've experienced throughout my life, I am not inclined to trust that whoever might be appointed to me would actually, that doing so would be in my best interest. It seems like, and I mean this entirely respectfully, however the system came to be the way that it is, but it seems like people who are, I don't know if they're formally called public defenders, but that they're just as often desirous of pleasing the state as much as they are their clients. And so, given that, and given the strange and bizarre nature of not only this case, but all the other cases that have, and just various informal accusations and allegations that have been brought against me, I think it's of the utmost importance that a person would actually have legitimate concern and care for me to be able to represent me effectively, and I just don't see that happening by a public defender.
Okay. Are you done? I mean, I want to hear you out, and then I'll answer, Mr. Iyer.
The judge is probably the most fun part of this. She's all world weary. I mean, we've had her on before. I like her. She's all world weary, and she's like, all right, dummy. She's more professional than that, but that's what she's thinking.
That's as much as I have to say, Your Honor. I don't want to seem like a fool, for everyone knows that it's not smart to represent yourself, but I really don't think it's the wise decision to make. If I could afford an attorney, I would certainly try to obtain one. I would much prefer that, but I can't afford one, so it is what it is. Okay, Mr. Ireton. So, yeah, well, we'd all love to have Marvin Belli if we could for our defense, but I don't even know if he's still living, and I'm probably dating myself now, but he was a very famous criminal defense attorney at one time. I think he was one of O.J. Simpson's team. So anyway, I understand your position. So you have the absolute right to represent yourself, okay? Constitution says that. That's completely up to you. When you hire a lawyer, okay, you can fire a lawyer. You hire, you fire, right? They're not doing the job in your mind. You get to say, all right, I'm going to go on to Attorney B. It's different when they're assigned to you, because then you have to be able to demonstrate that this attorney has not fulfilled their competency or acted in a competent manner as far as representing you on a criminal level. Okay, do you understand the difference there? So a court would make a decision based on whatever it is that you come up in with, saying your attorney, let's say your attorney has represented you for a month and never came and saw you once. Okay, that's pretty clearly a step below competent, right? We would agree on that. Whether or not your attorney is competent is a judicial decision based on what has transpired up to that point in time. So the judge would listen to you, listen to the attorney, make a decision about whether or not the attorney's performance has been deficient or below par. So what I'm telling you is, if you want to represent yourself, that's just fine and dandy. We'll keep going this way. But I think you're right to question yourself. What is that old saying of somebody that represents themselves has a fool for a client, or something along those lines?
No, you were correct.
But what I'm saying is, you can always change your mind in the future. If you start working with the attorney and you truly feel they don't have your best interest at heart and are not doing the job, I mean, they're not. These attorneys are very good attorneys, for starters, one, okay? Two, you may find out you actually like working with them, and then who is the silly one, right? So if you get into the situation, you're being
Who's the silly one? I think we all know.
represented, you don't think they're doing the job, you've kept your notes, you delineate why you don't think they're doing the job, then the judge can make a decision about whether somebody else can be appointed. And if you've gone through all the list of people and everybody is legitimately not doing the job, then you cross the road about whether or not you want to represent yourself or hire somebody. But those are your choices, Mr. Ireton. I can only lay out the choices. You have to make them. This is your crossing the road. Do you want to do your preliminary hearing as your own lawyer? I'm happy to do it. It's up to you.
Yes, Your Honor. As it stands, I do feel like I can make a pretty strong argument to at least handle the initial considerations of the matter. The question I would have regarding an attorney would be if I...
So far, it's merely garden variety stupid, but don't worry. Don't worry. It goes downhill.
would have any say in who the attorney would be that would be appointed to me. There are two names. One attorney that's I did accept to have appointed to me in the civil case parallel to this matter. It does seem like she cares about the case and is regardless of...
Who is that now?
Emily Gunville, Your Honor.
The civil case. So there's 3 attorneys that are on the Michigan Indigency Defense Commission for felonies in Dickinson County. So no, you don't get to pick. They would pick. You start working and working with the attorney, and if it doesn't work out, so be it. So Mr. Jaspin is in charge of who would be assigned if you qualify. The court has no control over that. They changed all those rules about a year ago. It's completely independent of the court now. So I have no choice. You have no choice. Whoever comes up next.
Well, then I would be, as it stands, inclined to represent myself. Mr. Jaspin has already demonstrated hostility might be a strong word, but verbal...
and he's only one of 3 attorneys, so I don't know who would be coming up.
If he's deciding, I've not heard anything good about him generally, and he has not been, I don't think he's been a good lawyer to me, so I would rather, as it stands, I would rather...
You heard him, Your Honor. He'd rather.
As it stands, I would rather move forward representing myself, Your Honor.
That's basically what...
Well, I think it's your lucky day, because the only one you haven't complained about is the one apparently that's up next on the list.
Is that Mr. Stubek?
No.
I've only complained about one, I thought.
Mr. Jaspin, I thought you were complaining about Mr. Seibel.
It's less of a firm complaint, but I have spoken
Okay, make that 2.
to him on approximately 1.5 occasions, and not to speak against his general competency as a lawyer. I don't know how to explain this, Your Honor.
Let me stop you. Okay, I'm not going to ask you any more questions. Other than, do you want to sign counsel or do you want to represent yourself? There's 3 attorneys. The luck of the draw. The 3rd attorney might come up. You don't know who's going to be it, but that's Miss Anderson. She's an excellent attorney. You'd be lucky to get her.
As it stands, I would like to move forward representing myself. And
Very well. That's your choice, sir. All right. So,
You're allowed to be that stupid.
in regard to today's probable, I'm going to find then for the record that Mr. Ireton has been informed of his rights. Let me ask you this then. Are you waiving your right to a lawyer here today freely, voluntarily, and understandingly?
yes, Your Honor.
All right, for the record, I'm going to find Mr. Ireton has waived his right here today freely, voluntarily, and understandingly. I will accept the waiver, and we will have the probable cause conference. Mr. Ireton, we're set for a preliminary examination a week from Friday. What, if anything, did you want to address today on the preliminary examination? On the probable cause conference.
Well, without knowing what I'm allowed to bring up, the 2 things I would like to touch upon. One would be, and I would think this would come first, but I brought this up last time, that it seems outrageous for them to be even attempting to charge me with first-degree child abuse. And so I would like to if it's possible, to talk about that. I don't think it's guilty of child abuse at all, but if anything is reasonable, it would be 4th degree at the most.
All right, so that's
Bold start. I think I should be charged with 4th degree instead of 1st degree.
Bold strategy, Compton. Let's see if it works
Which
out
is
for you.
effectively an admission of probably all but one element of the offense.
part of what we're going to handle at the preliminary examination, because the point of the preliminary examination is that the prosecution has to put on evidence, probable cause to believe a crime or crimes were occurred, probable cause to believe you committed that crime or crimes. As far as the probable cause conference, I'm not going to be making any kind of evidentiary calls or any kind of calls. The court, for purposes of setting bond, is to presume the allegations contained in the complaint are true. And if you want to address bond today, you can address bond. That's one of the issues that's contained under the umbrella of of things that can be handled on the probable cause side.
Yes, Your Honor, I do want to address bond. I just thought it was intrinsically tied to bond.
Yes.
What degree of crime I was being charged with. As I understand it, that dictates a large part of what the bond is set at and whether it's even a reasonable.
You were arraigned, dummy. So they read you the charge. So, you know, these are the sorts of things you're supposed to know.
If the charge is not reasonable, then the bond would be inherently unreasonable.
All right. What else do you want to address?
All right. Go with that, I guess.
I suppose the main thing then would be the prosecutor's assertion, and I don't even remember the laundry list of whatever she brought up in the initial hearing, but I did last time explain to her how I felt like much of the standing allegations, if you would call them that she brought against.
He discussed his feelings and the fact that he doesn't agree with the allegations brought against him. Oh, sweet Jesus, here we go.
Asked me to justify the. One component I understand is that she requested that it be not 10%, whatever that, however word that. I think you understand.
Yes.
Based on some sort of accusation
Let's reiterate the prosecutor's arguments.
that I'm in.
Of course, Mike.
I think that's entirely unfounded and unreasonable. I've been entirely peaceful, and I get regularly yelled at and threatened with physical violence by others, and I never respond in kind. I always just leave it off. The people that have made such
I get regularly yelled at. There may be another T-shirt.
accusations suggesting that I'm an imminent threat and abusive, have themselves been abusive and threatening to me. And so if a person were to actually look into these allegations, it would not take long for them to realize that they are unfounded. And I believe I brought up last time how the sheriff himself, after if I forget if you signed it, Your Honor, there was a no trespass order that was issued against me from allowing me on the courtyard property, but the allegations contained therein were entirely unfounded.
Is that for the personal protection order you're talking about?
No, Your Honor, it's by Judge Mia from in front of the court matter.
Yes.
Oh, okay. No, it wasn't me.
Okay. Well, however many people signed it, unfortunately, I don't know how many of them were really aware of what all went into that, but when I called the sheriff's department within a few days, I believe, after I was issued that, with a specific question about a specific allegation in there, that led eventually to me speaking personally with the sheriff over the phone, and he ended up investigating the matter. Unfortunately, it wasn't until after he signed it, so his hands were kind of tied as to what he could actually do, but he did at least investigate it and found that essentially all of the allegations were unfounded, and the only thing that they had left to stand on to justify the no trespass order was that I was sitting on the front lawn of the courthouse, which to my awareness in no way, shape, or form justifies a no trespass order. It greatly inhibited my ability to handle, to interact with the courts. Like, they're the ones forcing me to interact with them. I'm trying to live my life peacefully, mind my own business, and contribute to the community and society. They're forcing me to interact with them, and then at the same time, they're making it more and more difficult progressively over time. So I don't know if she can actually respond to that and explain that if she has investigated. I was hopeful that she would herself investigate that no trespass order, because I believe that the degree to which that no trespass order was unfounded, unwarranted, and entirely deceitful, I believe that that's representative of all of the accusations and allegations against me that I'm aware of. I don't.
It's borderline spurious.
Actually, no. It seemed like she was pointing to the sticks.
And with that, we will pause right there. We will bring this episode to a close, but come on back tonight for the remainder here from day one. Have a great afternoon again. We'll see you.